Court of Appeals is now in session. Please be seated.
Good morning. Welcome to the Court of Appeals in a special session here at Southern Utah University in this beautiful hall that always puts me in mind of something right out of Harry Potter with the banners and the knight at the back and so forth. We appreciate council's joining us down here. The Court of Appeals is a court of statewide jurisdiction, and it's appropriate, in our opinion, that we hold sessions of court places other than our comfortable building in Salt Lake City, although this is every bit as comfortable, if not more comfortable, than that is. Let me just run over the schedule for today that will be of interest to some of you in the back. We're going to hear arguments in this case at 10 o'clock. We're then going to take a recess, and we will conference at that time on this case and two others that are on our calendar for today that are not being argued. We will then reconvene in this room at 11:30 and hear arguments in the case of State versus Hunt. That will then blend into a Q&A session moderated by President Wyatt of the university, himself once a prosecutor in Cache County, who indeed argued cases at the Utah Court of Appeals on, we think, 3 occasions. With those preliminaries then out of the way, we will call the case of State versus Wright, the only matter that we'll hear argument in at 10 o'clock. And it's pretty much the same routine as if we were in Salt Lake. There's a digital clock on the podium that will show you how much of your argument time is left. Appellant can save some time for rebuttal. Let us know at the outset of the argument how much you want to save. Apparently it's 3 minutes.
Yes, sir.
I'll make an effort to help you keep track of that. And because we live stream the proceedings and also record them, if each time you would come to the podium you would identify yourself for the record, then if we have occasion to listen to these arguments down the road or somebody is listening in even as we speak, it will be clear who is saying what when. Anything else that needs to be mentioned? Very well, then we will hear argument in State versus Wright as soon as you're ready.
Thank you, Your Honor. It is nice to be here. I actually started at SUU, so it's like coming home a little bit.
That's great.
Only my parents keep changing the room and remodeling the house. They build a lot here. So may it please the court. My name is Nathan Bertzel, and I'm here representing Mr. Blake Wright. In May 19th, 2011, Blake Wright was awoken from a telephone call asking him to come into Juab County Sheriff's Office and discuss an incident that happened the day before. Mr. Wright's been incarcerated since that day. A few days later, Mr. Wright was charged with a litany of crimes, including aggravated kidnapping and attempted murder. Mr. Wright was unable to work, to afford to hire an attorney, unable to interview witnesses, unable to research the claims against him, and unable to review the evidence independently that was against him. He was wholly dependent upon his appointed counsel. Unfortunately, his appointed counsel, the trial attorney, was also unable to do many of these things and inadequately represented Mr. Wright. Under both the United States Constitution and the Utah Constitution, an accused is guaranteed the right to assistance of counsel. And the necessary corollary to this right is the right that the assigned counsel must render, quote, effective assistance of counsel. The United States Supreme Court has stated that the benchmark for judging any claim of an ineffectiveness must be whether the counsel's conduct so undermined the proper function of the adversarial process that the trial cannot be relied on as having projected a just result. And that's Lafayette versus Cooper. Of course, as this court's aware, to establish a claim for ineffective assistance of counsel, the accused has to show 2 things. One, defective lack of objective standard reasonable judgment, and secondly, prejudice. In this case, Mr. Wright unfortunately entered a guilty plea upon the advice of his counsel. I'd like to address that in just a few minutes, but where there's a guilty plea, to demonstrate the prejudice, we have to show that there's a reasonable probability that but for counsel's errors, he would not have pled guilty and would have insisted on going to trial, and we believe that's the case in this instance.
Is it enough? Oh, I'm sorry. Is it enough to demonstrate that but for the bad advice, he would have proceeded to trial? Or is part of your burden in showing prejudice that without the bad advice, he would have proceeded to trial and would have had a better outcome than he got via his plea?
I don't think that can be said because it's a plea. So I don't think you have to demonstrate that there's. We would have to, essentially speculate as to what a jury would have come back with, which is almost impossible to do. That we're really pushing that speculation. So I don't think we need to demonstrate that not only would he have gone to trial, but the trial would have been better. Although I think we can in this case, frankly. I think that honestly, I think that's actually pretty easy to do in this case.
Can you on all counts, or are you just focusing on the attempted murder count and the aggravated kidnapping count?
I think on most counts we can, given time restraints, page restraints in the brief. We haven't briefed most, but if you focus, if you identify that attempted kidnap or the aggravated kidnapping, that's our first degree felony. We're life without the possibility of parole. That's what he's facing. We take that, if that one count, just that one count goes away, we're in an entirely new ball game. If we get aggravated kidnapping away, which I think we should, and I think the prosecutor's overcharged. I think that happens. I think that I think that the facts of this case are pretty dang clear that there's no kidnapping. Pushing somebody is not kidnapping. I think the facts of this case, pulling somebody, not opening a garage door is not kidnapping. But that's the advice that Mr. Wright never got. He never got that opportunity to say, I don't think I did this. Instead, the advice that he got from his counsel was, you should plead guilty because it's easier to get that overturned than a jury verdict.
What about Mr. Nielsen's argument that it was actually watching the jury react to his mother's testimony that could have persuaded him?
Persuaded Mr. Wright to say
to plead guilty rather than bad advice from counsel.
I guess I can understand that question. I think if you put that in the timeline of events, however, it doesn't necessarily draw out.
And I take it from that you mean the filing of the amended information and the preparation of the statement, or something
partially that, yes, Your Honor, but also partially just looking at. We have a situation where it was emotional testimony. What mother wants to get up and testify that her mother or that her son slapped her around? No mother wants to do that. And I'm sure that the jury was emotional, and I'm sure that impacted Mr. Wright. I wasn't there, and so I can tell you I know Mr. Wright says he never asked for that.
The corner I think you may be boxed into, though, is that, unlike in some cases, we're not left to sort of speculate, just from inferences to be drawn from a record, who might have been thinking what. But in conjunction with the motion to withdraw guilty plea, as I understand it, there was an evidentiary hearing held, and both counsel and your client were sworn and testified. And they told very different stories. But the trial court, sitting as fact finder, found and credited the testimony of the attorney, namely that it wasn't his idea, it was his client's idea. And that his client said such things as, I don't want to put my mother through this, I see how upset the jury is, please see if you can talk to the prosecution, get me a deal. And with those findings, in essence, having been made by the trial court, it seems to me like you've got a difficult row to hoe in arguing that, well, never mind all that, never mind what the trial court found, look behind that and consider these several colorable contentions of ineffective assistance of counsel. What do we do with the conflicting testimony and the dispute that was resolved by the trial court as fact finder?
Well, let's assume that it happened exactly as trial counsel testified. Let's just give that timeline. The question I have then is, well, so what? If a criminal defendant on the third day of trial comes and says, hey, let's go see what's the best deal you can get me, does that abrogate the attorney's obligation to render effective assistance of counsel? Does that mean that the attorney no longer has to provide competent legal advice? Does that nullify the attorney's obligation to be prepared for trial? I think the answer to that question is no, and that's what I mean with Judge Toomey when I talk about the time. Even if he said before lunch, let's see if we can get a deal, and then the negotiations go on, that attorney has to say at some point, listen, you got a fair shot at getting at least not convicted on some of these crimes. Let's talk about that. You need all the information to make a competent decision. I need to talk to you about the merger doctrine and how that applies to your case, which there's no evidence that ever took place. And that's the time frame we have. And so, we do criminal defense work frequently in my firm. We frequently have individuals who come in and to say, what's the best deal you can get me? Go give me the best deal. But that doesn't stop or put some line in the sand to say, okay, now I don't have to do any legal work. You're still entitled to competent legal counsel. You've got to be prepared.
So you think it was incumbent upon counsel to say, deal schmeal, no way, we have got a solid case here, and we can beat the rap on. All the state is willing to give up is the possibility of a life sentence without possibility of parole. That's all they'll take off the table. We can do better than that at trial, and here's why. And I wish I could think of a phrase better than run roughshod over the rights of his client, but use his best efforts to talk counsel out, or talk his client out of what the trial court found to be his personal desire to make a deal. You think it was incumbent upon counsel to use his best efforts to persuade him otherwise. You don't want this deal. We can do better at trial.
I think that's exactly what an attorney. Not roughshod over rights, and certainly the defendant obviously has the right to accept a deal or reject a deal or make a counteroffer. That's their decision, but it's incumbent upon the attorney, who's allegedly and supposed to have the information and the legal knowledge and the acumen to give proper advice. You've got to advise your client.
The argument you made in your brief, and I expected you to make right there and you didn't, was that the deal that was cut on day 3 of trial is informed by the position the client was put in by what had happened over the course of the 3 days. In other words, you're only able to negotiate a deal as good as the bargaining position you're in, and the argument you made in your brief, at least I think you made in your brief, was that Mr. Harmon put him in that position by not preparing for trial, not calling certain witnesses, not interviewing people, and so forth and so on. Is there a reason you're not making that argument now?
No, other than I'm watching the time tick down.
Okay.
That's the only reason why. No, that's exactly right, and that's what I kind of get in. If bad information comes in, a bad result's going to come out. So you have work that, and this is what I was trying to get at a little bit, Judge, that an attorney has the obligation to be prepared for trial. They have the obligation to have witnesses prepared, witnesses to go forward. That wasn't done in this case. And that's why in the brief we say Mr. Wright really had a Hobson choice here. That's no choice at all. He believes, because that's what his attorney has told him, you're going to be convicted. And he believes that because he just saw his attorney for the 2.5 days not present any defense. In fact, his attorney says in the beginning of the trial that he's not really comfortable moving forward at this juncture. Mr. Wright says, we have discovery issues, conflicts between me and my counsel that are not resolved.
Yeah, in a situation like that, the state isn't going to be willing to make all that many concessions in a plea deal. I mean, the best plea deal you're going to get in that situation, I mean, you're not holding any cards.
Well, and in that instance, what should happen, what the trial counsel should do is to say, this is the best deal we can get you. Now, here's the problems with your case. Now, maybe there's a conflict of counsel issue at that point, because maybe he needed to admit, I wasn't ready. We don't have the evidence. They didn't have any of the evidence. They don't have the evidence. She didn't suffer a subdural hematoma. She had a stroke. And I'm not sure. I mean, this court, I think, should look at that again and sua sponte, send that back under Rule 23B so we can get that finding on the record. But man alive, that seems pretty clear to me. bad information in led to a bad result. It led to a bad deal. He should have never accepted it. And his attorney should have told him, you're insane to accept that. If you make this, if you say, here's the legal, here's the factual, you're wrong to accept it, you shouldn't accept it, I wouldn't recommend you accept it, and they accept it anyway, they can't turn around and say, well, I got bad legal advice. You got great legal advice. You got great legal advice. But when your legal advice is, it's easier to get your plea overturned than it is a jury verdict, and that's the legal advice you're working off of, it's not helpful. So,
Mr. Birdsall, I'm going to ask you a question. This
Okay.
won't come out of your rebuttal time.
Okay.
A housekeeping detail. As you know, this is a case in which we have many more ancillary and supplemental filings, pro se motions and the like than is typical. And I want to make sure that I'm clear on where we stand with respect to unresolved matters, and I count 2 at this point and would appreciate your telling me if there's more. Number 1, the motion to strike and the response, that issue remains pending with respect to the state's supplemental authority and your response there too. Secondly, your client appealed from the denial of his second request for appointment of substitute counsel, and that was transferred by the Supreme Court to us. We consolidated that appeal with this one. Does that issue remain alive for resolution in conjunction with this appeal, or unbeknownst to me, did we wrap that up some other time?
I have not seen any resolution on that matter.
Okay. Is there anything besides those 2 by way of loose ends? Obviously, the big deal here is the resolution of your primary appeal and the arguments that are raised.
Yeah, not that I'm aware of.
Okay.
You know, this obviously Mr. Wright feels very snake bitten by justice, right? He's not a big believer in our courts at this point. And I don't take what he's said about me or to me or written to you personally. I hope that you can see that you kind of see that through his filter, his point of view. I certainly don't take it personally. I try to understand his perspective of being incarcerated, and in his view, completely unlawfully and improperly incarcerated. In fact, I share some of his views that I think that comes across in the briefs.
Well, that's very generous of you to say. Speaking only personally, it appears to me that at least in your hands, he's had the benefit of very competent counsel.
I appreciate that, Judge. The reason I mention that is I don't believe that there are any other outstanding issues. Mr. Wright may at some point listen to this transcript and say that lion Nate Birdsall's getting me too, and say there is another issue. But at this point, I really don't believe that there are.
Okay.
So.
Thank you. You'll have your 3 minutes on rebuttal. We'll hear from the state, and maybe Mr. Nielsen can begin by indicating whether you are aware of any other loose ends other than those 2.
I am not, Your Honor. I think you've
Very good.
correctly stated what those are. May it please the court, John Nielsen for the state. All of these ineffective assistance claims are foreclosed by the trial court's credibility finding. Defense counsel is litigating in an alternate universe where something else happened than actually happened. What happened is trial counsel testified. We're on the 3rd day of trial. His mother is testifying. The jury has heard the recording that Mr. Wright made of himself beating his elderly mother nearly to death. And they're crying. And he looks at his client and he says, okay, I'm ready to cross-examine her. He says, don't cross-examine her. She's been through enough. Well, do you want to testify? No, I'm not going to testify. Well, now what? Well, maybe we should seek a plea deal. And that's exactly what they did, and that's exactly what they got.
But shouldn't counsel have been arguing at least that the kidnapping charge should be dropped in exchange for the plea right here and now?
For reasons that I've articulated in my brief, first of all, Finlayson merger doesn't exist anymore. Wilder got rid of it. Common law merger is dead. So even if counsel had argued that, it would have been fruitless because that sort of merger doesn't exist anymore. And counsel, I guess I can jump to the third issue on merger here.
Well,
Counsel,
before you do, let me just make sure I understand the procedural posture. I mean, you're relying heavily on Judge Taylor's findings at the subsequent evidentiary hearing, and I get that.
Sure.
There's some reasons you're relying on that. They're very good for you. But they're not appealing that decision. Do I understand that correctly? They're not appealing Judge Taylor's decision to deny the motion to withdraw the plea. making ineffective assistance of counsel claims, which is not a direct appeal of that decision Judge Taylor made. Do I have that right?
Well, here's the issue. So they're claiming he pled guilty. He's claiming ineffective assistance of counsel in connection with a guilty plea. So to prove prejudice, he has to prove that but for the alleged deficient performance, he would have gone to trial. There is no deficient. Judge Taylor's finding there informs that analysis because we know what actually happened. We know why he pled guilty.
Well, but that doesn't seem to me anyway to fully answer the question, right? For the reasons I explored with Mr. Birdsall a minute ago. He may very well have decided on day 3 of trial that my best option here is to plead guilty because I am so sunk at this point because of what's happened in the 3 days in pretrial preparation that I'm going to go ahead and assent to this guilty plea totally voluntarily because my counsel, through non-preparation and all the things that are delineated in the blue brief, has put me in a position where I have no other better option. And it seems to me your argument is basically saying that under that scenario, there is no IAC claim. And I just want to make sure that I'm understanding you correctly. Is that what you're saying?
What I'm saying is that a defendant could certainly claim that and say, but for this, then I would have gone to trial. But the trial court disbelieved all of that. That's not what happened. He keeps asserting it. He asserts it strenuously and repeatedly, but the trial court didn't believe that.
Well, as I understand the state's position, the timing here is of key importance. He did not on day 2, after losing some argument about evidence coming in or failure of counsel to have done something in the way of preparation. It's on the heels of the mother's gut-wrenching testimony that he says, no, don't cross-examine her. Let's see if we can make a deal. So as I understand your position, at least, and correct me if I'm wrong, okay, all these many pre-trial and preparation and mistakes of ineptitude and the like may all have happened, but that ends up being water under the bridge when we get to the point of the testimony of the mother, which is the sole proximate cause of why he wanted to make a deal. And in essence, that washes away any prior misdeeds on the part of counsel, because what prompted the desire to enter a plea was her testimony and her testimony alone, which is going to come in. Perhaps if there was an argument, oh no, for 1,000 different reasons here, that she should not have been permitted to testify, then I think he'd definitely have a stronger argument. But assuming the jury at some point was going to hear her testimony anyway, and given what the testimony was and the reaction it prompted on him, maybe I exaggerate your position a little bit, but I thought in essence you were saying that's all that ends up mattering.
I think that's true, but I also think that there's not a record that counsel committed any misdeeds. These are all allegations that have no factual support, and I would like to point, Judge Harris, this maybe goes a little bit to your question, talking about being in a stronger bargaining position. When Mr. Wright was represented by Ron Yangich, the testimony was he was offered 2, I believe, second-degree felonies and a Class A misdemeanor. That is a screaming deal on these facts. That was when Mr. Yangich represented him. So this was well before trial, before he was even represented, because Mr. Yangich was hired to represent him on some other cases, and he just kind of offered he was trying to wrap everything up together. So Mr. Defense counsel here was working with Mr. Yangich, and they were trying to wrap this all up. And as part of that global resolution that they were seeking, the testimony was that I believe it was 2 first-degree felonies and it was 2 1-to-15s concurrent or something like that, and then a Class A misdemeanor, which is an incredible deal when you're facing this many serious first-degree felonies with damning evidence that the state has.
Well, he's only facing 1 first-degree, right?
Oh, I guess attempted murder is a second. I'm sorry. Aggravated kidnapping would have been the first. But still, you're facing something with a life top on it, a life without parole top if you prove serious bodily injury, which the state was going to be able to prove here in several different ways. So, again,
taking the hematoma stroke issue out of
yeah, the broken ribs are enough
the
under
ribs
this
are
court's
enough.
decision in Lellier.
Bruised spleen is enough.
Absolutely, absolutely. And regardless of whether it was a stroke or a hematoma, as I argued in a previous brief, the state could have just come around and said, well, okay, he caused the stroke by hitting her. That's something that can happen too. So in some ways it's just semantics. Who cares about the substance of that? He's going to be convicted on these things. He's going to be convicted, and he's going to get life without parole on this. And he salvaged something at the only time he could. And Judge Orme, you asked counsel whether he is required to also prove a reasonable likelihood of a different result. According to Lee versus United States, he does not. But the likelihood of a different result does play into the would he have pled analysis. I think that's what that case makes clear, because Mr. Lee was somebody who was dealing drugs out of his restaurant, and he confessed. They had a search warrant. I mean, he was dead to rights. And what he claimed was, look, I have a right to at least go to trial because this is my only shot. If I get convicted, I'm being deported. I'm going to leave the country that I've been in for 30 years or whatever, however long it was, basically his lifetime. And the court said, okay, the prejudice is the loss of the trial right. It's not the reasonable likelihood, because that's what the government had argued, that he'd also have to show, look, he's dead to rights here. He can't show Strickland prejudice. So Strickland prejudice is slightly different in the plea bargaining context, but the strength, of the prosecution's case does definitely play into that, because as Chief Justice Roberts said in his opinion, when somebody is looking dead to rights, they're going to have a hard time proving that that they would have a reasonable likelihood of that they would have foregone their jury trial in order to get a better deal. And he did get a better deal. He did get something out of this. And he could have gotten something a lot better if he had pled sooner, but he put his mother through all of this. It's understandable why at that point the state would say, well, we're on day 3 of trial. We're not willing to make we know what's going to happen here. You know, there's no spoilers. Everybody knows what's going to happen here. And it's not, and even if there were instances of deficient performance on Mr. Harmon's part, even if he had done all those things, the defendant's theory was far-fetched at best. He wanted to claim, and you can see this in the record, 1029, page 20, where his claim was that, well, all of these injuries came because she fell down the stairs, like she initially said, though she said that was because she was lying, because Mr. Wright made her do that, and that his sister somehow caused some of these injuries when she was caring for her elderly, beaten-up mother. That was not going to fly, and none of the witnesses that he says should have been called when counsel went through all of them, it's like that wouldn't have helped. That would have made no difference at the end of all of this. So even if we were in some parallel universe where we're looking at these as if these are trial IAC claims and the jury went to verdict and then he made all these claims, because that's what the brief reads like. It's like a trial IAC brief. Even with all of those, he still couldn't prove Strickland prejudice based on the obviously very compelling nature of the mother's testimony and his making a videotaped record of the crime, so at least a partial one. And I don't know if the court's taken the opportunity to watch that yet, but you can hear the mother moaning and begging as he essentially repeatedly threatens to kill her. It's very moving. So there is no likelihood at all, let alone a reasonable one. And faced with that sort of damning evidence and seeing the reaction on the jury's faces, that's what prompted Mr. Wright to plead, and that's why he can't prove his ineffective assistance claim. I would like to talk briefly about the merger issue. Counsel is now essentially raising a statutory merger argument for the first time in a motion, in a response to the state's 24J letter. I did, on page 50 of my brief, footnote 13, flag for this court that, hey, the state's argued this in Wilder, and as soon as Wilder came out, I just said, by the way, the court has decided this now, the Finlayson issue is over. He argues in his opposition to my motion to strike on page 2, he says, no, well, in the responsive brief, we've argued this. I asked counsel just before argument here what he meant by responsive brief because I couldn't find it in any of the defense briefs. He said, well, by that I mean my response to your 24J letter, essentially. The cases are legion that counsel cannot raise new issues in a reply brief or an oral argument. How much more so in a 24J response letter?
Well, I would ordinarily, and maybe I still am, I would ordinarily be rather sympathetic to that argument, although it seems here like this is a little bit unique in that, I mean, the state apparently saw Wilder coming and helped bring that about, but Finlayson merger would have been the better vehicle, I think, to advance at trial although at trial, if we already knew then what we know now, namely that Finlayson merger was going to vaporize, the alternative statutory merger argument would no doubt have been advanced. And I wonder if maybe defendant is entitled to a little more wiggle room than usual, where the operative substantive law has changed in a way that was perhaps unexpected.
If statutory merger didn't exist up to that point, I might agree with you that there could be an exceptional circumstance. I assume that's what you're essentially alluding to. But where I pointed out as I pointed out in my response brief on page 50, there are three kinds of merger in Utah law. You have the single larceny doctrine, you have Finlayson merger at that time, you did anyway, and you have statutory merger. This was Finlayson all the way down. It was Finlayson in the trial court, and it's understandable to see why, right? Whenever you have a kidnapping offense and something else, defense counsel essentially always at least they always did when it existed, make a Finlayson claim. So again, I don't think we can litigate in a parallel universe where this happened before Wilder and then counsel obviously goes in another direction. And I would point, even in Wilder, in his brief, the court said that he fleetingly made a statutory claim as well. The court said, well, that's an interesting question. We're not going to decide it. Even in Mr. Wilder's case, Wilder didn't even get the benefit of that in his own case. So how much more so? Again, this option was open. Counsel could have made this argument. They didn't. It's way too late to raise this now. Oh, I would like to address something as well that came up. Judge Toomey, you asked, or at least you alluded to, the preparation of the statement and the timeline as far as that went. There is a stamp there on the plea papers that says 10:45 a.m. And it's true that the court didn't recess until noon for lunch. But I think under the circumstances, given that that stamp is on there and that the defendant's signature and everything else is on there, that stamp means it was received by the court. That's what it is. You know, at any trial court, there are former trial court judges here. No, that's the clerk just taking in the papers that are being filed, right? It could not possibly have been filed at 10:45. The prosecutor at that point would have been doing the direct examination of Mr. Wright's mother at that point.
Well, it does just seem a little confusing.
The only reasonable view of that is that something was wrong with the timestamp, because the parties clearly didn't recess until lunch, and up until that point, the prosecutor is at the podium directing Marilyn Wright at that point. So that couldn't possibly have happened that way. There is no timeline problem. All we have here is a stamp problem. I think that's the only reasonable inference to look at from the record that we have.
Couldn't a different employee of the prosecutor's office have filed it downstairs or something? I mean, it seems like you're assuming a lot of facts there that I'm not sure are in the record.
Well, here's the deal. Here's the issue as I see it. It's stamped, which means that the court has received it, and defendant has signed it. If he signed it an hour ago, why in the world are they still doing the direct examination of the mother?
Why is trial continuing?
Exactly. It had already been signed by all the parties at that point. I believe it had been signed by the trial judge. And they wouldn't be going through this kabuki dance for an hour or more. There's just no other reasonable way to look at that. And if there are no further questions, I urge this court to affirm.
Thank you. Mr. Birdsall, you have the last word. 3 minutes worth. Words, I guess I should say. You have the last words.
Thank you.
Well, you can limit yourself to one if you want.
All right, Nathan Birdsall again on behalf of Mr. Wright. Briefly, regarding the timestamps, the prosecution initially says we just filed amended jury instructions, and you can look and see in the record amended jury instructions were filed that morning, correctly time-stamped, and then subsequently there are timestamps were long before anyone says that Mr. Wright asked for a plea deal.
Was it possible that a document could have been filed with a timestamp before it was signed by the judge and the defendant?
I think it could, sure. I think it could. That front page is stamped. Not every page is stamped.
If you assume it was already signed when it was stamped, I think Mr. Nielsen's argument is sort of unassailable, right?
Well, one of two things happen. Either the timestamp in the Juab County Court in Nephi is really wrong, or something else happened. And if it's really wrong, then that goes to what the state is saying, that hey, the stamp's off, it's not reliable. Or what Mr. Wright is saying, I think that I never talked to my attorney about a plea deal before, and we were already filing the documents necessary. Now, is it possible to swatch out the signature page for a non-signature page? I guess it could. That could happen. I'm not saying that it's proper or should have happened, or even that there's evidence that it did. I'm just raising that as a possibility. We're speculating as to why do we have a timestamp that's clearly can't be accurate, that it could not have been signed before. There are, I'm going to work backwards. Oh, I've got a minute. Okay, merger. The question before this court isn't just whether it should have merged, but when can a merger claim be made? That's the question we're asking. Now, that's a novel question in Utah, although it's been addressed by many, many other courts, and they've said this exists to protect constitutional rights. And so the courts that have evaluated have said this always exists. We can always do merger, and that was the basis for the denial of merger. Merger wasn't denied in this case because of substantive issues. It was denied because it was after the plea had already been entered, even though it was before sentencing. You've waived it. That was the argument, but there's nothing written down that says you're waiving your merger rights. And so our claim on appeal is merger's available. The trial court erred by not even reviewing it. And it should be reviewed. And I think that the analysis, I think we're kind of tripping over ourselves when we're thinking, well, this is statutory merger versus Finlinson merger. Because statutory merger and Finlinson merger for these sorts of kidnapping cases is essentially the same, and that's what I point out, and that's what I tried to point out in the responsive to the supplement.
What's your response to Mr. Nielsen's citation to Wilder, where Mr. Wilder essentially made the same argument you're making now, and the Supreme Court said, too bad?
Well, they said you didn't raise that in the court below, and you also didn't raise that in the petition for certiorari. And where that's a court of selective limited jurisdiction, the Supreme Court, they have the right to say, man, we don't have to listen to that. Mr. Wright's here on appeal as of right, and I think it needs to be on this table where it's certainly not fair for the state to be able to say, hey, we've got a pending brief in another case and you should have to respond. I want to incorporate by reference all of those responses, and that's what we say in our reply brief. I can't possibly respond to what you've written and didn't even provide me in another case and what they might choose to do. And so we're putting the cart way before the horse. But now that Wilder's come out, I think this court should at least indulge the idea and to say, okay, we may not have used the right terms of same act, but does Finlinson in this where it says it has to be it has to be something more than just the underlying act. It's got to be. I was doing so well too. I'm missing a word. But there has to be more to it. That we're kind of talking about the same thing. It's a rose by any other name. It's still a rose. We've made the same arguments, and I think it would be fair to this court to look at it from that perspective, particularly in light of the surprise. This right is this that I believe is constitutional, or that actually it is a constitutional right. We're not going to look at it. We're not going to look at it under Finlinson, which has 10 cases that we can look at and help evaluate. We're going to look at this kind of blank statute now that hasn't really ever been litigated because everyone just did Finlinson. So I think it's fair for this court to look at it under that guise and to say, okay, is this really the same thing in the same act? And those are questions that Wilder specifically left open. That said whether or not this could be the same act or what constitutes the same act, we don't know, but luckily we hear merger all the time, so we're going to get to that. I think this is a good case to start on.
Thank you, Mr. Birdsall.
Thank you very much.
We very much appreciate the arguments from both sides. They're very helpful to our understanding of the case. We'll take it under advisement, and we will reconvene at 11:30 to hear arguments in State versus Hunt, which will then lead into the Apex Colloquium event and question and answer conducted by President Scott Wyatt. So we'll see you again at 11:30.
Court of Appeals is in recess until 11:30 a.m. Thank you.